Hello and welcome to Politics Tonight, where we dig and go beyond the headlines for informed analysis of major political stories in Nigeria. I am Olajumoke Olatunji. Special Advisor on Media and Publicity to Abia State Governor calls on President Tinubu and Inspector General of Police to investigate allegations against Governor Oti over allegations that he is using state funds to sponsor litigation of Peter Obi and IPOB activities. On the interview segment for today, we focus on the Nasarawa State Governorship Election Petitions Tribunal, which declared PDP candidate David Umbugado winner, with an Abuja-based legal practitioner and PDP lawyer, John Matthew, as our guest. Welcome to Politics Tonight. Stay with us. We'll be right back. Welcome back to Politics Tonight, and thank you so much for staying with us. Now, let's begin with some developments in the polity. The Special Advisor on Media and Publicity to Abia State Governor, Ferdinand Ekoma, is calling on President Bola Tinubu and Inspector General of Police to investigate allegations against Governor Alex Oti, over allegations that he's using state funds to sponsor the litigation of Peter Obi and IPOB activities. Some groups had made these allegations in separate press conferences, where they also said Governor Oti had concluded plans to intimidate the justices to deliver the tribunal judgments in his favor. Mr. Ekoma called on security agents to invite the young men, as the allegations are weighty and have the propensity to cause disaffection, insecurity and breakdown of law and order in the state. An auxiliary nurse, Feisha Ogedengbe, has been identified by the Lagos State Police Command as a prime suspect in Mohbad's death. Apart from Ogedengbe, who is the prime suspect, Naira Marley, Sam Larry, Prime Boy, and one other have also been named as suspects. At a press briefing in Lagos, the State Commissioner of Police, Idowu Owuwa, said Ms. Ogedengbe administered multiple and highly potent injections on Mohbad, whose real name is Ilerioluwa Aloba. The police revealed that the injections consisting of tetanus toxoid, paracetamol and cetrizone, an antibiotic, were administered at Mohbad's residence on the 12th of September. The medications were said to have triggered an immediate reaction, including vomiting, goosebumps and convulsion.
At about 14:35 hours on 12th September 2023, Ms. Feisha eventually arrived armed with one pack of cetrazone injection, one vial paracetamol injection, tetanus toxoid injection, one vial procaine penicillin injection, 7 ampoules of IM diclofenac, tincture iodine, several needles and syringes. Ms. Feisha administered the tetanus toxoid on the arm of Mohbad and gave both the paracetamol and cetrazone injection intravenously. Immediately, the cetrazone injection was administered. Ms. Feisha confirmed that Mohbad started vomiting, while goose pimples appeared on his face and all over his body. At this point, it dawned on Ms. Feisha that Mohbad was reacting to the administered medications.
In other news, Oyo State Governor Seyi Makinde is urging members of his cabinet to craft strategic policies and programs that will directly benefit residents. Governor Makinde gave this charge in Ibadan during a 3-day leadership retreat for political appointees, thought leaders and top government officials. Oladu Yewole has more.
This 3-day leadership retreat is attended by political appointees, members of the State Executive Council, and top leaders in Oyo State. The aim was to set the stage for decision makers to collaborate and develop effective strategies in line with the Omitutu 2.0 agenda for sustainable development.
Some of these things will condense it.
In his address, Governor Seyi Makinde emphasized that achieving every plan aimed at benefiting the citizens necessitates a collaborative effort involving all government appointees and stakeholders.
So there will be interagency collaboration, and you have to know what role your department, your ministry, or your agency will need to play to support others.
The retreat is entitled Exploring the Implementation of the Oyo State Roadmap for Sustainable Development 2023 to 2027. In view of this, resource persons called on decision makers to develop homegrown solutions to the myriads of challenges confronting the citizenry.
Our challenge will be to be able to find a way out in a world that is characterized by volatilities, uncertainties, complexities, and ambiguity.
On their part, members of the Oyo State Cabinet reviewed how they would utilize the potentials in their various ministries to impact the state's development.
We see that we have the environment, and even if you go out on Friday and go to you want to lodge in any major hotel, you find it difficult to do so because people are tuning into Oyo State. And that's the reason why we are collaborating with agencies like OSEDA, like my brother, and lands, so that we can have very good environment to satisfy our vision.
Both citizens and the organizers of this retreat anticipate that the event will benefit the entire state. Oladio Yewole, TVC News, Ibadan.
Right, let's take a short break, and when we return, it's about time to speak with our guest of the day, who is an Abuja-based legal practitioner and PDP lawyer, John Matthew. Tonight we're discussing the Nasarawa State Governorship Election Petitions Tribunal, which declared PDP candidate winner. Stay with us. Welcome back to Politics Tonight. Now let's get to our interview with the guest of the day. I am joined by an Abuja-based legal practitioner and PDP lawyer, John Matthew, for discussion on the Nasarawa State Governorship Election Petitions Tribunal, which declared PDP candidate winner. Thank you so much for joining us, Mr. Matthew.
Thank you very much for having me, and good evening, viewers.
Right, good evening to you. So let's start with the Nasarawa State Governorship Election Petitions Tribunal proceedings. How will you describe this journey?
You mean the judgment?
Yes. The proceedings, how will you describe the journey?
Well, the Election Petition Tribunal, which sat and had the petition of the People's Democratic Party governorship candidate, David Emmanuel Mugadu, and the PDP, against the three respondents, INEC, Governor Sule, and the All Progressive Congress, did a very, very fantastic job. There was a proper application of the law to the facts as were presented before the tribunal. Ample time was given to all the parties to ventilate their grievances, and at the end of the day, a proper judgment befitting of the facts and the law as presented was rendered by the tribunal. Even though it was a split decision of 2-1, in law, the majority decision is the decision of the court, and we are quite pleased with it.
Right. So this tribunal invalidated Governor Sule's election and declared PDP candidate as the winner. How were you able to achieve this legal victory?
Well, to appreciate how this judgment came about, it will be important for me to give a clarity as to the petition of the petitioners before the tribunal. This was one of the most straightforward petitions which any tribunal that is willing to do justice will have no difficulty in arriving at a decision like this one has done. You will appreciate that in Nasarawa State there are 13 local government areas. Elections were conducted on the 18th day of March in the entire state. After the election, the INEC, which was the first respondent in the petition, declared Governor Sule as having been elected. The aggrieved party went to the tribunal, and this was the case he took to the tribunal, that the sum total of the votes cast at the polling unit, when added, does not show that it was Sule who was declared by INEC that won the election. And so, it was a simple case of presenting the election results in the various polling units in the areas complained of for the tribunal to recompute. And these areas were few. The major thrust of the petition was in 2 local governments, Lafia and Awe, 2 electoral wards in Awe, Azara and Kanje Abuni, and then 3 electoral wards in Lafia, Chiroma, Gayam, and Ashige. So the complaint of the petitioners in the wards in Awe and in Lafia, 2 of the wards in Lafia, is that if you calculate the results emanating from the polling units, which is the foundation of any election, of the pyramid of any election, if you calculate the results from these wards, you will find that the sum total of the votes emanating from the various polling units does not reflect what is reflected in the ward summary. And therefore, the petitioners invited the court that, please, here are the results, duly certified and given to us, to the petitioners by INEC. Here are they. Accept them as exhibits, recompute, and see that our case is just. This was exactly what the tribunal did. And in doing so, they arrived at the decision which they did, which, in my opinion, is an infallible position.
All right. So this was a split judgment. Okay. Please go ahead.
There were, of course, a few other areas which the petitioners also complained. 4 polling units spread across 3 local governments where complaints of overvoting occurred, which was also established by evidence before the tribunal. And then 1 in one of the local governments, Doma, where there was no collation, even though elections were successfully concluded at the polling unit. So the relevant forms were presented. For instance, in respect of the overvoting, the 4 polling units, the results of the relevant polling units were presented, the register of voters were presented, and the beaver machines that were used for accreditation were not only presented, but the screenshots were duly certified and tendered before the court as exhibits. So these were the evidence that were presented before the court, that the court made a determination that, yes, in these 4 polling units, you have established overvoting, and therefore we're cancelling for all the parties in these 4 units. And then the 1 unit in Doma, where the results were concluded, but inexplicably omitted from the collation process, they duly collated it. The tribunal has jurisdiction to do so, and they did exactly what the petitioners asked for them to do, because the evidence was overwhelming. It was presented before the court. And the interesting thing that you may need to know is that even while this petition was ongoing, if you access the IREF, which is the viewing portal for everybody to see the results of the elections, you will find that it is in accord with what the petitioners were saying in court. So there was no magic about it. This was a very clear petition that no tribunal that wishes to do justice will have difficulty in arriving at the position like this tribunal indeed did.
Fantastic. So, like I was trying to say, it was a split judgment, and I'd like to know the implication of this. The lead judgment was by Justice Ajayi and was supported by Justice Onaga, while Justice Ibrahim Mashi delivered a dissenting judgment upholding Sule's election. What's the implication of this?
Well, like I told you earlier, the majority judgment is always a judgment of the court. Of course, in a panel of 3 justices, every judge is allowed to render his opinion. Where you have a panel of 3 and 2, in this case the chairman and member 1, give a judgment, that is the judgment of the court. Anybody who is dissatisfied can only resort to appeal. That is the judgment of the court. And I want to tell you this. The curious thing about the dissenting judgment is that one of the issues that the dissenting judge hinged on was that the witnesses that were produced by the petitioners, some of whom were INEC, most of whom were INEC witnesses, INEC staff, who were subpoenaed to the court to produce documents and to testify on behalf of the petitioners. The dissenting judge took the view that they were not competent witnesses and ought not to have been allowed to give evidence. The curious thing about this is that in another petition decided before this very one, because there were actually 2 petitions before the Governorship Election Petition Tribunal in Nasarawa State this time around, this election cycle, the New Nigerian People's Party also filed a petition. And that judgment was rendered before the judgment of the PDP. In this judgment of NNPP, this same dissenting judge allowed the testimonies of subpoenaed witnesses who are INEC witnesses. He had no trouble with that. It was a unanimous judgment. So to turn around the very minute after delivering that judgment, allowing subpoenaed witnesses in the same circumstances, like the witnesses who testified for the PDP, to now give a dissenting judgment is quite curious and baffling. Apart from that, the entire body of the petition, of the judgment of the dissenting judge is basically what you might call technicalities, which has no place in our jurisprudence anymore. And it's not surprising. The only way you can defend such a petition that has clear, lucid facts and evidence presented that were duly certified by INEC, produced from INEC, the only way you can defend such a petition is to resort to technicalities. So I actually understand and sympathize with our colleagues on the other side, because it was a very difficult task to defend such a petition. On the facts as presented, there was absolutely no way anyone could reasonably counter those facts. I'll give you an example. When we contend that the sum total of the results from the polling units do not add up to what is being presented at the ward summary, and we presented duly certified copies of the results of the various polling units complained of, it behoved on on the other side to bring their own copies of results in these polling units to show something contrary. That was never done. So the tribunal was left with only one set of results, which were duly certified. And the petitioners, in this case, did not just rest on even the polling unit results that were certified. We tendered pink copies of the relevant results. We also tendered copies downloaded from the IRF, duly certified in accordance with the law, and tendered, all of which are in agreement that the figures as reflected in the various polling units were indeed inflated when they were being entered in the ward summary, to the extent that even in the dissenting judgment, the figure he came out with as a margin of victory for Governor Sule was about 3,900 and something, as opposed to over 64,193 that the INEC declared as the difference between Governor Sule and the PDP candidate, Right Honorable Dr. Emmanuel Mbugadu. So where did the 60,000 votes come from? Where? It's a very serious indictment on the role INEC played, the role the coalition officers played. Where did they get the figures that they added to the APC and the candidate? And then why did they reduce the votes of the PDP and its candidate? These were the questions that the tribunal answered. We're happy. They were bold enough to do what was needed. The tribunal indeed had the jurisdiction. There are a plethora of judicial authorities on the fact that a tribunal seized with the results in the circumstance of this tribunal has the bias to calculate and come to a determination as to who won. That is why the judgment came as it did. And it will be difficult for anybody to want to disturb such a judgment.
All right then. So, I mean, the tribunal also directed INEC to withdraw certificate of return from Governor Sule and issue same to Mugadu. Now, is this an indictment on INEC or APC?
Well, you see, even in our petition, INEC is the first respondent, meaning we are convinced that INEC did this hatchet job of declaring a result when they had the facts and evidence before them to the contrary. INEC's collation officers were the ones responsible for collation of results at the various wards complained of. And these were staff of the Federal University Lafia. Most of them were staff of the Federal University of Lafia who were engaged by INEC as ad hoc staff. They had these figures. You know, I would say if these were mistakes of maybe a couple of hundred, or maybe even 1,000 votes, I will understand. But 64,000, this is mind-boggling. In one single ward alone, they added over 30,000 votes, 33,000 to be exact. That's in Chiroma ward, 33,000 votes to a political party while reducing that of the PDP. In Gayam ward, they did the same thing. And then they went to Ashige ward, where elections were duly completed, results entered in the B summary. It was taken to the local government collation center for collation. Then it was inexplicably cancelled when they had no authority to do so. The only authority that has powers to cancel elections for any viable reason is the presiding officer. Even at that, he will now do a report and fill what we call from EC40 GPU, along with the report, and submit to the next level, which is the Ward Collation Center. And such a report will also be uploaded in the IRF. This is what their rules provide. But nothing of such was done. And when we petitioned and complained about this and asked that the results be restored, what did the respondents do? The answer was that there were violence, overvoting, and so on and so forth in the 36 polling units of that electoral ward in Ashige. The interesting thing
Mr. Matthew,
is that, if I may just add this
Mr.
aspect, the
Matthew.
interesting thing is that in that very ward, there was also the State House of Assembly election that took place contemporaneously. The result of that election was declared. So there was no violence when it came to the State House of Assembly election, but violence in the governorship election. All
right. So in your statement, you said INEC did a hatchet job. Do you have any evidence to back up that statement?
Evidence is even in the findings of the tribunal. If the tribunal, even the dissenting judge, came to the conclusion that that was not the margin, INEC made a declaration with a margin of 64,193 votes. The dissenting judge, I'm not even talking about the majority judgment, which gave it to us. The dissenting judge said Governor Sule won by 3,900 and something, less than 4,000 votes. It means that INEC secured 64,000, about over 60,000 votes, and gave it to the APC. Where did they find that from? Where? That cannot be acceptable as a mistake. In two electoral wards, it's unimaginable. So that is why I refer to it as a hatchet job. The evidence is there. It is glaring. It is in the IRF. They were asked to recompute. They refused. They were asked to cross-check the results in the IRF before they enter these wrong figures. They refused.
So talking about dissenting judgments, Mr. Matthew, talking about dissenting judgments, Justice Marshall ruled that PDP did not win the election. So INEC may be right after all.
No, I just gave you an example now. I said even the dissenting judgment did not agree with the figures that INEC gave. INEC, the dissenting judge said the margin was 3,900 and something, less than 4,000. INEC declared Sule with a margin of over 64,000. So even the dissenting judge did not agree with what INEC did. So it is completely indefensible. And like I keep on saying, like I said right from the beginning of this program, that these results are still available on the IRF for anybody to access and see the figures. I mean, it was so brazen that you pick a polling unit result, you will see, for example, PDP scoring 50, APC scoring 100. Then you come to the B summary where the results are supposed to be entered in the relevant column. That 100 scored by APC here turns to 700. The APC's 50 now turns to 25. This was what took place in over 100 polling units in Chiroma electoral ward and in 58 polling units of Gayam electoral ward. So when the results were presented, no tribunal, what it sought, that is ready to do justice, can close its eyes to such brazen infringement of the electoral laws.
All right.
None.
All right. So as a lawyer, what aspect of that judgment do you consider as instructive?
I beg your pardon?
As a lawyer, what aspect of that judgment do you consider as instructive?
Well, first and foremost, the judgment demonstrated the authority and the powers of the tribunal to step into the role of the Independent National Electoral Commission to do the needful where it is seized with the results of an election and where the complaint borders on improper computation, like was done in this case. They have reaffirmed their position as demonstrated in a plethora of cases. And I just cited one, Aduma versus Oronsi. It's an old decision as far back as 2010, delivered by a judge that is presently now in the Supreme Court, to the effect that the tribunal seized with the results, duly entered results, duly certified results, has a bias to recompute it and determine who won the election. This is what the tribunal did. This is the defining moment. And you will find that there's an interesting aspect in the new Electoral Act 2022. In Section 137, it makes a provision that where the non-compliance complained of by a petitioner is manifest on the face of the documents, you don't even need witnesses to speak to those documents, because a witness is not going to alter what is in the document. So the tribunal did the correcting by collating these results and making a return of the person who duly won. And this was a defining moment. The other aspect that I wish to address is the aspect which the dissenting judge latched onto. That is, with subpoena witnesses cannot come to the tribunal and give viva voce evidence. Their lordships in the majority judgment did not agree. The dissenting judge, like I pointed out earlier, agreed that such can take place in the judgment of NNPP, only to turn around full cycle in the judgment of the PDP, which were all both delivered the same day, one after the other, to now say that a subpoena witness cannot give such evidence. Now, who were the subpoena witnesses that we brought? These subpoena witnesses were INEC witnesses. The INEC was the first respondent in the petition, and the subpoena were served on the INEC as an institution. They chose to send those particular witnesses to come and give evidence. They gave evidence as they were rightly entitled to, because a subpoena is an order of court commanding you to either produce documents or produce documents and give evidence. And they were entitled to give those evidence. Those evidence were receivable, they were duly received, and the tribunal was justified in acting on them. And this is what resulted. So this was a defining moment, that their lordships had the courage of their conviction to look at the documents that were presented before them and come to a determination as to who won the election.
All right. So APC has now rejected the tribunal judgment, described it as monumental error. How will you react to that?
The APC?
Absolutely.
You said, sorry, I didn't get you quite.
APC has rejected the tribunal judgment. The party described it as monumental error. So I'm asking you to react to that. How will you react to that statement?
Well, the truth of the matter is every party who is aggrieved by the decision of a court, particularly in this instance, has a right of appeal. The right is exercisable within 21 days in case of a final judgment, or 14 days in case of an interlocutory decision. So, this judgment was rendered on the 2nd day of October. They have 21 days within which to appeal. It is their constitutional right to pursue the appeal. We are willing, we are ready. If the processes are served on us, we will respond accordingly. But I want to tell you that an appeal is not something extraordinarily new. It is by way of a rehearing. So it is going to be predicated on the facts and the law as canvassed at the lower tribunal. So I do not expect anything radically new from the Court of Appeal, given the fact that the evidence is so overwhelming and the facts were presented in such a lucid manner that it will be difficult for another superior court to upturn it. The entire gamut of the defense, the entire basis of the defense was predicated on technicalities. No, this is not the witness you ought to bring. You ought to bring this witness. No, the witnesses did not speak to the document. All position of the law. Present position of the law, having regard to our claim before the trial. Because, you see, the nature of evidence you present in any case is dependent on the reliefs you are seeking and the facts you have brought to court for adjudication. We are not quarreling with elections at the various polling units. That's not the petitioner's quarrel. We all agree, both sides agree, that the elections were duly conducted at the polling units. Now, what is the sum total of those polling unit results? This is what was in issue. We presented the results from polling units, and they didn't present a contrary result. What did you expect the tribunal to do?
So it's also interesting to see that you're talking about overwhelming evidences, because the APC is also insisting that the party presented overwhelming facts and arguments against the petition and wondered how the tribunal arrived at its decision. So what will you say about that?
I keep on telling you that the case of the respondents is predicated on technicalities, which is why I gave you an example. They are saying that the witnesses we brought to come and present our case ought not to be the witnesses. They want, for example, in Chiroma ward, where there were 100 polling units, we should bring 100 witnesses from each of the polling units. That would have been the law. That would have been the case if our complaint bordered on elections conducted at the polling units. For example, if our complaint is that there was violence in polling units, there was a fight, there were overvoting, this was not our complaint. Our complaint in those polling units were that elections were peacefully conducted in all of them, but that in summing up the total, there were mistakes. This person's vote was increased to the detriment of the petitioner. This is our case. So the relevant witnesses that ought to give evidence were the people who were present when the computation was done, which were the witnesses we presented. In the areas we challenged on overvoting, we brought specific polling unit agents of those areas and tendered the relevant forms, i.e. from EC8As, the register of voters, and the beavers and the beaver screenshots to establish overvoting. This was a decision recently rendered in 2023 in Oyetola and Adeleke by the Supreme Court as the necessary ingredients you need to prove overvoting. We did this in 4 polling units. The tribunal agreed with us. So we can't get worried about people who are only ready to talk to technicalities. You are trying to block justice by putting roadblocks. Unfortunately, even these roadblocks do not enjoy the position of the law. There is always a presumption of regularity when elections are conducted. So when the results were brought, to polling unit results were brought, the law presumes them regular. And so when in computing them, you see that the figures do not add up, you have no choice as a tribunal. So the entire dissenting judgment is predicated on technicalities. I'll give you an example. The dissenting judge says, oh, the agents that came to testify did not prove that they were agents. Now, the second respondent, who was the only one who even brought witness, the first and second respondent did not even have a defense because they didn't call one single witness. So the second respondent who called evidence, of the 22 witnesses that testified for them, only one brought an agent card. The rest did not bring agent cards. He was comfortable with that. Under the Evidence Act, evidence of somebody who witnessed an event or we had an event, who saw or participated in an event, is the relevant evidence that ought to be brought. These people we brought, who were respective agents of the party, had a right to be in the various wards where they witnessed and participated in the election, and indeed signed the relevant forms which they identified before the tribunal. What more can be needed? All right. What more?
Well, Mr. Matthew, one of the the contentious issue is Ashige Ward. Can you explain to us what happened in that ward and what was the tribunal's position?
Well, Ashige Ward is one of the wards in Lafayette local government. It's comprised of 36 polling units. Out of these 36, elections were conducted in 35. These 35 polling results were taken to the ward collation officer of INEC. The ward collation officer entered the results in the relevant form EC8B of the ward, signed it, and all the party agents, including the party agent of APC, signed the relevant forms, where PDP had 4,000 plus, APC has 2,000 plus. They took this result to the local government summary, that's the local government headquarters of Lafayette, for collation into the form EC8C. It was at this level that the local government collation officer directed that the entire result be cancelled on the ground that there was overvoting. Now, we challenged this position in the tribunal, and what was the response of the respondents? They said that there was violence in the various polling units. That is why the results were justifiably cancelled. Now, like I said, there's a presumption of regularity in favor of any result. If you are claiming that there is violence, then you have the onus of establishing that there was violence. They didn't bring any, like I said, the INEC, which even raised this defense, did not call one single witness throughout. All right. They only tendered from EC40G, filled by the ward returning returning officer, ward collation officer of INEC, the first respondent, who has no powers in the first place to cancel the result. The powers is resident in the various polling unit presiding officers.
Mr. Matthew, let's